Greetings to you all. My name is Patience Mkuyu. I'm a researcher with the International Water Management Institute in Southern Africa. This presentation is part of two ongoing research projects, the first being a water research funded project titled Operationalizing Hybrid Water Law for Historical Justice, and another funded by the Policy Institutions and Markets Program of the CGIAR, titled Recognizing Customary Water Tenure in Hybrid Water Law. The Water Research Commission project is currently in its second year and will end in December 2022. And it has an overarching aim of addressing the historical imbalances that exist with respect to water allocation by conceptualizing a hybrid water law implementation plan. This plan will take into account living customary water law arrangements, as well as how base statutory provisions can be leveraged towards practically addressing these imbalances. This presentation builds on the current discourses on equity and justice and how they are experienced in the former homelands of South Africa. Homelands were established during South Africa's apartheid era of segregation policies, where Blacks were made to occupy 13% of the country's total land area, and therefore dispossessed of their ancestral land and natural resources. These areas are currently where thousands of small-scale water users are not sufficiently represented and protected within statutory water laws. I'll give a brief overview of the limitations within current legislation and how they enable imbalances in the access to water. And lastly, I conclude by offering some insights into how the legislation can be better suited to meeting the demands of small-scale water users in the former homelands. The 1998 National Water Act repealed the 1956 Water Act, whose main features included riparian rights afforded to water users adjacent to rivers and streams, and who enjoyed prioritization in use and access. Riparian rights would make the allocation of water difficult, as use of riparian resources was not strictly regulated. These rights were mostly accorded to white users during the apartheid government period. This is one of the principles the new act sought to do away with in democratic South Africa. Water governance in former homelands was left to the discretion of traditional authorities. The 1998 Water Act in many ways is a progressive piece of legislation which calls for the equitable allocation of water resources, being cognizant of existing historical prejudices. Nonetheless, its practical implementation and even its interpretation have been less impressive. Sunset clauses still exist within the law 23 years after independence. The National Water Act currently contains some enabling clauses for continued inequity in water access, such as the recognition of existing lawful uses as enacted under the 1956 Water Act. The existing lawful uses for Black users that takes the historical inequalities as a starting point is only now receiving attention. Secondly, implementation of compulsory licensing, which should mean the reallocation of resources and dislodging of existing lawful uses held by many whites, and the setting aside of water for the historically disadvantaged has been slow. The National Water Act commits to guarantee the basic human needs reserve, but its implementation is lagging as many users in former homelands find themselves without water for domestic use. This basic human needs reserve is also vaguely defined and does not include water for the right to food as provided in the Constitution. This is particularly vital in areas where water services fail and people rely on self-supply for even basic domestic uses. Yet there is no enforcement of the basic human needs reserve. A general authorization meant to address the small-scale user majority and thereby reducing the administrative burden of licensing thousands of small-scale users is set at a low threshold, particularly in stressed catchments. and is set at about 2,000 cubic meters per annum, equivalent to roughly 0.2 hectares. The South Africa National Constitution provides at least 5 important clauses for the protection of rights to water, food, non-discrimination, and also for the recognition of customary laws. The first is equality and non-discrimination, which declares full and equal enjoyment of all rights and freedoms with no racial or cultural discrimination, for example. Through the redress and property provisions, the state is given the responsibility to provide an enabling environment for citizens to gain access to land on an equitable basis, and as such, the state is given the authority to take legislative and other measures to achieve land and water and related reforms to redress past racial discrimination. As alluded to in the previous slide, the right to sufficient food and water is insufficiently realized in the former homelands who still struggle to get water for domestic use, let alone water for food. Lastly, the Constitution also gives authority to the courts to apply customary law where applicable in recognizing the right to customary uses. Case law precedent gives examples of how the rights to customary laws have been validated. The two cases of Alexo versus Richterfeld highlight the unique relation between land and water and other resources in customary laws. The court provided a precedent on the recognition of the rights of an indigenous community to restituted land. Baleni verdict, where mining rights have been allocated over land occupied by the communities, also showed that customary laws and rules could have authority and the community was allowed to give consent for mining rights. These rulings have huge implications for the recognition of customary water rights in the former homelands. This map shows former homelands in the shaded areas in the Inkomati Catchment, where small-scale water users own parcels of land between 0.1 to 5 hectares on average. In most cases, the allocated 2,000 cubic meter allocation accorded through a general authorization becomes insufficient to meet the unlicensed water demands. Water supply service is intermittent to non-existent, and some communities have resorted to developing self-supply water systems. There is no express security for such self-supply in statutory legislation. Implementation of the basic human needs reserve and its operationalization are not adequately articulated compared to the ecological reserve. Irrigation is the largest water user, taking up over half of the total allocated volumes. There are very few Black individual registered users, which may point to the vast majority of those not registered and potentially criminalized in their use due to the inaccessibility of the licensing system. White individual users on average use over twice as much water per individual for irrigation. In the next slide, the picture shows more clearly how there are more users in the low volume bracket, a situation which therefore complicates the licensing process if all users using more than 2,000 cubic meters are to be licensed as the law stipulates. Users in the low volume bracket are exempted from licensing through the general authorization and Schedule 1 exemptions. While these provisions allow for the authorization of lower volumes of water of use, they are also a weaker entitlement compared to a license, making those who hold this entitlement vulnerable and almost invisible compared to the larger users. In summary, we can say that statutory water law provisions have not explicitly acknowledged customary water tenure. There is a clearer recognition of land rights compared to water rights under statutory law. Statutory regulations implemented in South Africa do not adequately address security of tenure for the many water users and fall short of securing and assuring their supply of water. Customary land and water tenure are inseparable, but are separated in statutory legislation. This is a source of potential friction in the implementation of statutory water law on customary territory. I therefore conclude with the following submission. An amendment of the National Water Act that expressly recognizes customary water uses would be a progressive advancement. Raising the general authorization threshold to above the 2,000 cubic meters per annum would legalize use for thousands of small-scale water users. Expedition of the compulsory licensing process to dislodge wide existing lawful uses and enable the reallocation of water would also be a positive step towards redressing historical injustices. With this, I would like to thank you for your attention.